On the record prior to bringing in the jury.
Good morning, Judge. I don't believe we do. No, Your Honor. Thank you.
All right, let's go get the jury. Tammy, you're going to need to slow Caitlin down.
All right.
You just come down. You can have seats anywhere. Everyone can have a seat. How's everyone doing this morning? Good evening. Well, what we're going to do today, we're going to do opening statements this morning. We have a bus set for a jury view about 1:30, so opening statements probably will take probably till 12:30, and if you want to get lunch before you go on the jury view, and then after the jury view, you'll be sent home, and then we'll start with evidence tomorrow morning at 9 o'clock. So if you can be here at 8:45, we'll get hopefully get started on time. But remember, be patient on that. What I'm going to do first is read you some warnings and admonition as to how you're going to go through the trial. It is important that you be fair and attentive throughout the trial. Do not discuss this case among yourselves or with anyone else. Do not permit anyone to discuss it with you or in your presence. Do not form or express an opinion in the case until it is finally submitted to you. More difficult for you to understand is you may not discuss this case among yourselves until it is finally submitted to you. You will receive the opening statements, the evidence, the arguments, and law in that order. It would be unfair to discuss the case among yourselves before you receive everything necessary for your decision. You must explain this rule to your family and friends. When the trial is over, you'll be released from this instruction. At that time, you may discuss the case and your experiences as a juror, but are not required to do so. Until that moment, you must control your natural desire to discuss the case both here and at home. Do not talk with the attorneys, parties, or witnesses during the trial. Likewise, the participants in the trial must not talk to you. If anyone should attempt to discuss the case with you, report the incident to the court or the bailiff immediately. You may not investigate or attempt to obtain additional information on this case outside of the courtroom. This would include any research on the internet, in the libraries, in the newspapers, or in any way make any investigation on this case on your own. Do not visit or view any place discussed in this case, and do not use internet maps or Google Earth or other programs or device to search for or to view any place discussed in the testimony. Do not research any information about the case, the law, or the people involved, including the parties, the witnesses, the lawyers, or the judge by using a computer, smartphone, iPad, or any other device or application that accesses the internet or any social media such as Facebook, Twitter, Instagram. And the Supreme Court wants me to say, don't look anything up on MySpace. Do not read any news stories or articles in print or on the internet or in any blog about this case or about anyone involved with it, or listen to any radio or television report about it or about anyone involved with it, or let anyone tell you anything about any such news reports. If you want, you can have your spouse or a friend clip out any stories and set them aside to give you after the trial is over. I assure you that when you have heard all the evidence, you will know more about this case than anyone will learn through any media, and it will be more accurate. In short, you may not investigate or attempt to obtain additional information on this case outside of the courtroom. It is highly improper for any of you to attempt to do so. Any violation of these orders may cause a new trial or may require a penalty for disobedience. In the event you experience a personal problem, you may explain the matter to the bailiff or the court reporter. The message will be conveyed to the court. At each recess, I will repeat these warnings, but if I should forget to do so, you should remember them and apply them to your conduct throughout the trial. I'm not going to read through this after every break. If at any time you discover that you cannot hear or understand a witness or a lawyer, then please speak up so that the problem can be corrected. Before we hear the opening statements of counsel and begin to take evidence, I believe it would be helpful if you were to have some preliminary instructions to follow in listening to and considering the evidence, which you will hear in this case. Later, after you've heard all the evidence and closing arguments to counsel, I will give you further instructions covering additional law, which you are to follow in this case. It is the duty of the judge to instruct you in the law, and it is your duty to follow the law, as I will state to you both now and at the conclusion of all the evidence. First of all, it is your exclusive duty to decide all questions of fact submitted to you. In connection with this duty, you must determine the effect and the value of the evidence. You must not be influenced in your decision by sympathy, prejudice, or passion towards any party, witness, or attorney in the case. The attorneys for the parties will, of course, have active roles in the trial. They will make opening statements to you, question witnesses, and make objections, and finally will argue the case as the last step before you hear my final instructions and commence your deliberations. Remember that attorneys are not witnesses, and since it is your duty to decide the case solely on the evidence which you see or hear in the case, you must not consider as evidence any statement of any attorney made during the trial. There is an exception, and that is if the attorneys agree to any fact. Such agreement, stipulation, or admission of facts will be brought to your attention, and you may then regard such fact as being conclusively proved without the necessity of further evidence on such fact. If a question is asked and an objection to the question is sustained, you will then not hear the answer, and you must not speculate as to what the answer might have been or as to the reason for the objection. If an answer is given to a question and the court then grants a motion to strike the answer, you are to completely disregard such question and answer and not consider them for any purpose. A question in and of itself is not evidence and may be considered by you only as it supplies the meaning to the answer. As jurors, you have the sole and exclusive duty to decide the credibility of the witnesses who will testify in this case, which simply means that it is you who must decide whether to believe or disbelieve a particular witness. In determining these questions, you will apply the test of truthfulness that you apply in your daily lives. These tests include the appearance of each witness on the stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity he or she had to see, hear, and know the things concerning which he or she testified, the accuracy of memory, frankness of it or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because it was given under oath. You may believe or disbelieve all or any part of the testimony of any witness. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of the issue. Rather, the final test in judging evidence should be the force and the weight of the evidence, regardless of the number of witnesses on each side. The testimony of one witness believed by you is sufficient to prove any fact. Also, discrepancies in a witness's testimony or between his testimony and that of others, if there are any, does not necessarily mean you should disbelieve the witnesses, as people commonly forget facts or recollect them erroneously after the passage of time. You are certainly all aware of the fact that two persons who are witnesses to an incident may often see or hear it differently. In considering a discrepancy in a witness's testimony, you should consider whether such discrepancy concerns an important fact or a trivial one. This concludes my preliminary instructions to you, and I hope they will be of some assistance to you in listening to and considering the evidence. Please keep these instructions in mind as you listen to the evidence and statements of counsel. I may give you additional instructions during the trial. When the evidence and closing arguments are concluded, I will give you additional instructions on the law which you are to follow. Members of the jury, I would like this time to highlight the procedure of the trial. First, each of the attorneys will be given an opportunity to tell you what they expect their evidence to be. This part of the trial is called opening statements. The opening statements are not evidence, but they are a preview of the claims of each party, designed to help you follow evidence as it is presented. After opening, the state of Ohio will have an opportunity to present evidence. If the defense, after the state rests, then the defense will have an opportunity to present evidence. And if the defense presents evidence, then the state has the ability to do rebuttal evidence. And after that, we would go to closing arguments. Are there any opening statements on behalf of the state of Ohio?
On August 23rd, 2018, Donna Castleberry, a 23-year-old mother of two, was on the west side of Columbus when she encountered the defendant, Andrew Mitchell. Mitchell was working undercover as a Columbus police officer. He was in an unmarked vehicle. He was out on that side of town looking to see if there was any prostitution activity. Donna had turned to prostitution while battling a drug addiction and was working on that side of town. The two came into contact. Mitchell pulled up to her. They engaged in some conversation. She got in the car. She got in the front seat of the vehicle. They began to drive and engage in small talk. The two settled on a price for a sex act and drove over to an area, Yale and Bellows, where there was an apartment building. They drove onto that lot. Mitchell parked next to the apartment building. He pulled his car up so that her passenger side door was right up against the side of the building so that it couldn't be opened. They stopped there. There were child locks on the back of the vehicle too that were operated so she couldn't escape out of the back of that vehicle. As he stopped the car, he told Donna he was the police and she was under arrest. You'll hear an audio recording from the incident. Mr. Mitchell had a cell phone that he started before the incident. This is something they did to try to record the elements of prostitution that was tucked down into the side of the door. So the recording was going. You'll hear Donna's demeanor. She was polite and cooperative, but she said, "I don't believe you're a police officer." He showed her a plastic ID, not a shiny badge, a plastic ID card. And she said, "That looks fake. Where's your badge?" He told her he forgot it. He didn't have it that day. She became a little bit worried, asking more questions. "Well, you're gonna have to prove who you are. I don't believe you're a police officer. Where's your walkie?" No walkie-talkie. He tried to show her a piece of paper. She said, you can get that at the courthouse. So he said, "I'll text my buddy." Got on his phone and started to text. She sat there politely and calmly, you'll hear this on the audio, and waited. But then a fellow came out of the apartment building. His name's Randall Jackson. He came out and walked behind the car. He was headed over to a dumpster. At that point, Donna started becoming more fearful. She decided she was going to call for help, and the defendant got mad.
Can you help me, please?
Help you what?
Call the police Yes, I am.
He's acting like he's a police officer. And he's not. He has this in a fake ass bag. Kidnapping women. I've already heard about him. He already is wanted. His cops have been showing the pictures. You know that, right?
Yeah.
They've been showing the pictures.
Please, fuck you.
Don't put your hands on me. Don't put your hands on me. Do not put your hands on me. Do not put your hands on me. Don't put your hands on me. Help! Help!
She got a knife.
Help!
Cut me.
Help! Get off of me!
Just cut me.
Help! Help! Help me, please. I'm in the back door. Help me. I'm in the back door. He's coming. Help me. Get out of it. Please help me. Please help me. Get out of it.
Fucking nightmare.
Those were the last words of Donna Castleberry. You'll hear the entire audio, and you'll see that audio that's been synced up with some video. It's grainy building video, doesn't add a lot, doesn't tell us what exactly went on in that car, but you can see basic movement patterns. You can see Donna move to the back seat. You can see that the defendant's door was open when he shot her. You'll have expert testimony, witness testimony, photographs, and other evidence to help you decide this case. The defendant's been charged with 2 counts, as you've heard, murder for causing the death of Donna as a proximate result of committing a felonious assault, and you'll get further instructions on that later, and for voluntary manslaughter while being under the influence of sudden passion or in a sudden fit of rage caused by provocation of Donna that was reasonably sufficient to incite him into using deadly force, knowingly caused her death. He's asserted he was justified in using deadly force, claiming that he reasonably believed that Donna posed an immediate threat of serious physical harm to him. And the judge will tell you, officers are often forced to make split-second decisions in rapidly evolving situations without the benefit of hindsight. But this was not a split-second decision. This was not an officer firing to save his life. And we'll present expert testimony on this topic as well. I ask you to pay attention to the timing of the shots. The first shot was fired approximately 47 seconds after he said, "She has a knife." About 2 seconds later, he yells out he was cut. Cut by a woman who did so in a defensive manner. She was screaming for the police. She was screaming for help. She was the one trying to get away from him. She was not an aggressor. She was scared. She was begging a bystander to call the police and help because he didn't have the tools to prove who he was to her. Every action by Donna you'll find to be defensive. She was trying to get away. She was scrambling to the back seat of that vehicle. She was shot in the back seat of that vehicle. The knife was found on the front seat, his seat. He fired 6 shots over the course of 12 seconds. And you'll hear expert testimony that officers shooting to save their lives typically shoot at a rate of 4 to 6 shots per second. He wasn't reacting to an immediate threat. Yes, he'd been cut badly more than 40 seconds previously, but he was not acting to a threat that still existed. He had time to undo his seatbelt, to open his door, to reach down for a gun in a holster, to reach across, to fire, to pause, to fire again, to pause, fire again, and then a last shot. Officers have a duty to assess and reassess a threat. Officers are trained to deal with dangerous situations and dangerous people. And there's a duty to try to preserve life and to assess a threat and reassess it. Donna wasn't a threat. She was trying to get away. Everything you'll see over the course of this case will support that. The shot cadence here, 12 seconds for 6 shots, is not an officer fighting for his life. It's retribution. Thank you.
Any opening statements on behalf of the defense?
Yes, Your Honor. May I proceed?
You may.
May it please the court, Mr. Collins, Mr. Mitchell, Mr. Cable, Ms. Pritchard. Good morning, ladies and gentlemen. Before I begin, I know I speak for all court personnel when I say thank you so much. I know these last 2 years have certainly been trying, to say the least, during the course of a pandemic. But for you to be here, engaging in your civic duty to ensure that our client receives a fair trial, please know you are appreciated. Opening statements. Just as you heard the judge say, they are an opportunity for each side to lead you down a path of what each side believes the evidence will show. Or, as is the case here, it's an opportunity for me to lead you down a path of what we believe the evidence will not show. A roadmap or preview, if you will. Now, every time Mr. Collins and I prepare for a case, we look for what we call a theme. And what I mean by theme, ladies and gentlemen, is when you examine a case, you have witnesses, some professional, some not. You have evidence, some physical, some circumstantial. And those all sit on the periphery of a case. But what the theme is when you take away all the stuff on the periphery, the theme is what's left at the core fundamental concept of a case. And we believe the evidence will show that the theme of this case, ladies and gentlemen, is that on August 23rd, 2018, Andy Mitchell acted reasonably because he had a subjective belief that he was in imminent fear of great bodily harm or death, and second, that that belief was reasonable based on the totality of the circumstances in the eyes of a reasonable police officer on the scene. Now, it's important for you guys to know that it's not lost on us that someone lost a life in this tragedy. Someone lost a daughter, a sister, a friend. And the judge will instruct you that you are not to consider empathy or sympathy while examining this case. You're only to consider what goes on within these 4 walls. And we believe, ladies and gentlemen, the evidence will show that this decision to use deadly force was in fact reasonable. Now, unlike the majority of our cases that we try in our criminal justice system, we have a burden here. However, that does not alleviate the state of Ohio from meeting their burden of proof. It is they that must prove to you each and every element beyond a reasonable doubt. Each and every element of felony murder and voluntary manslaughter. If they fail to do so, the judge will instruct you, your analysis stops there. Now, if you find that the state of Ohio has in fact met their burden of proof, then and only then do you get to analyze our burden. The judge will tell you that our burden is proof by a preponderance of the evidence. He'll instruct you that that means of greater weight. Put simply, more likely than not, a smidge over 50%. And before we get to analyzing our burden, I want to first focus on the state's burden. As the judge will tell you, their burden of proof is proof beyond a reasonable doubt. Proof that you would rely upon in your most important of your own affairs. Care for an elderly parent, surgery for a child. It is our highest legal burden in our system. That is the standard of proof that the state of Ohio is held to. Now, they have to prove both that he knowingly committed a felonious assault, which proximately resulted in death, and two, that he acted in a sudden fit of rage or provocation, knowingly causing the death of another. We believe, ladies and gentlemen, the evidence will show that the state will not be able to come close to meeting their burden of proof. As the judge will instruct you, your analysis will stop there. Now, there's two reasons why we believe the evidence will show that the state of Ohio cannot meet their burden of proof. First is because the state's own witnesses are going to contradict one another. Second is because the state's own witnesses are going to contradict the untainted physical evidence that Mr. Collins spoke to you about in voir dire. The evidence will show that the state's case is comprised of two components. First, an audio and video syncing, and second, an expert, both of which contradict the state's own theory of the case. Now we'll break those components down. First, the audio and video syncing. You've already heard some of the audio recording of the incident, a recording that our client created when he was in the capacity working as an undercover vice unit for the Columbus Police Department back in August of 2018. He was working prostitution on the west side of town in an area known as the Bottoms. Now, in order to provide corroboration for their arrests, CPD records the elements of solicitation. Now, I am sure the state of Ohio is going to play that audio over and over and over again, and it is difficult to hear. Now, listen as they try to sync that audio with a grainy video that was captured by a building camera. Listen as you hear the inconsistencies of attempting to sync an audio with a video from two different sources and combine them into one. We told you, ladies and gentlemen, that the audio recording is difficult to hear. But what you did not hear in that audio recording, and what you will not hear and what you will not see any evidence of, is our client acting in a sudden fit of rage or provocation. What you did hear is "she cut me," and you will hear the struggle surrounding the felonious assault that was committed by Donna Castleberry. And ladies and gentlemen, Ms. Pritchard ignored the fact that the felonious assault did not stop. What Ms. Pritchard did not tell you is that after he was cut, Ms. Castleberry positions herself so as to begin to choke Mr. Mitchell. Now, the second component of why the state will not be able to meet their burden of proof is the expert. A man the state of Ohio flew out from Las Vegas, Nevada, who's going to come in and tell you that he came to his conclusion that the 47-second struggle was used to determine that this force was unreasonable. He's going to tell you what he based his conclusions on. Just like Mr. Collins talked to you about in voir dire, think of his report or his examination like a tabletop. His conclusion sits on the top of it, and what he uses to base his conclusion on are like the legs of a tabletop. Listen through the cross-examination and the challenging of the state's witnesses and the state's evidence as we knock those legs underneath that table, one by one. Listen as we drill down all of the false premises he uses to arrive at his conclusion. Listen for all of the material that Mr. Borden blatantly ignores that was a part of this case. Listen for all of the contradictions between this case and other opinions that he has rendered in the past. Now, the evidence will show that Jamie Borden contradicts the state's own theory and the state's own physical evidence. As such, ladies and gentlemen, we believe the evidence will show that the state of Ohio cannot meet their burden of proof. So again, as the judge will instruct you, your analysis would stop there. However, if you find that the state of Ohio has in fact met their burden of proof, then it is us, and we must prove to you, more likely than not, that on August 23rd, 2018, Andrew Mitchell believed he was in imminent fear of death or great bodily harm, and that his actions were reasonable, given the totality of circumstances in the eyes of a reasonable police officer on the scene with Andy's knowledge and Andy's training and Andy's perception. Now, normally, the judge will tell you to view these facts in light of your own life experience. However, your task, ladies and gentlemen, and it's not an easy one, is that the judge is going to instruct you not to view these facts through your own life and experiences, but rather view these facts from a reasonable police officer on the scene. And when you look at these facts, when you look at the totality of the situation, the judge will tell you, you cannot look in hindsight. Because, ladies and gentlemen, as we all know, hindsight is always 20/20. Rather, you must stand in Andy Mitchell's shoes as these things were occurring to Andy Mitchell. This is important, ladies and gentlemen, because unlike judges and unlike juries, officers on the beat are not afforded the luxury of armchair reflection. Every single day, our men and women on the police force put their uniform on and put their lives on the line, not knowing if they will return home to their families or their armchairs. Now, how are you going to judge what a reasonable police officer would do? Two different avenues, ladies and gentlemen, that will be presented to you in order to determine what it was that a reasonable police officer would do on the scene. First, the judge is going to give you some factors that courts have held you are to look at when you're evaluating the reasonableness. Second, you're going to hear from another expert, our expert. He's a man from Akron, Ohio, and his name is Kevin Davis. He's going to take these factors that the Supreme Court has used, that courts in Ohio has used, and apply them, help you apply them to the facts of what occurred on August 23rd, 2018. Mr. Collins and I want you to keep these factors in the back of your mind as you continue to hold the state of Ohio to its burden and us to ours. Factor 1, the severity of the crime at issue. Here the evidence will show that our client was feloniously assaulted. Evidence will favor reasonableness in this decision to use deadly force. You're going to hear the state's own witnesses tell you that Andy Mitchell was feloniously assaulted on August 23rd, 2018. Factor 2, whether Ms. Castleberry posed an immediate threat of physical harm or death to Mr. Mitchell. The evidence will show that Mr. Mitchell was slashed with a knife. Not a small knife. You're going to see pictures of the knife. You're going to see pictures of the slash. This slash required 34 stitches, an emergency transfusion, and surgery. Evidence will show this factor, too, favors reasonableness. You're going to hear the state's own witnesses tell you that when someone is confronted with a knife, they are feloniously assaulted and under the threat of serious physical harm or death. Factor 3, whether Ms. Castleberry was actively resisting arrest or attempting to evade arrest. You've heard this already today. Here, the evidence will continue to show that she was actively resisting arrest, and again, continue to escalate the situation. Evidence will show, ladies and gentlemen, this factor favors reasonableness in his decision to use deadly force. The state's own witnesses are going to tell you that she was in fact resisting arrest. Factor 4, the suspect's demeanor, whether she was intoxicated and non-compliant. You're going to hear evidence that Ms. Castleberry was on cocaine. She was on fentanyl. She was on a veterinarian drug. She consumed these substances no more than 3 hours before the incident. You're going to hear what Ms. Pritchard didn't play for you earlier, that she wanted to score more dope, and she had heroin on her person. The state's own witnesses and a joint stipulation, ladies and gentlemen, are going to tell you about her demeanor. They're going to tell you what substances were in her system. All of this evidence is going to show you exactly why Ms. Castleberry was not compliant on August 23rd, 2018. Factor 5, the duration of the confrontation. Evidence will show that this confrontation lasted approximately 47 seconds. The confrontation and struggle of life and death did not stop until Mr. Mitchell shot to stop the threat from occurring. The state's own witnesses are going to tell you just about how long that confrontation lasted. Factor number 6, the possibility that the suspect may be armed. Evidence will show, ladies and gentlemen, this was no possibility. This was a fact, an uncontroverted fact, that Donna Castleberry was armed on August 23rd, 2018. Now, these factors will demonstrate that Andrew Mitchell was reasonable when he decided to use deadly force. And that is what the evidence will show. You're going to hear that on August 23rd, 2018, Andy Mitchell and other members of the Vice Squad had to be present at the shooting range for firearms qualifications. This means that Vice went to the range earlier that day and took a refresher course. Present at the range was Vice Squad Sergeant Mike Evans, who you'll also hear from. Sergeant Evans is going to tell you they all drove separately to the range and proceeded with that training, led by Officer Gagnon. You're also going to hear from Officer Gagnon. He led the entire unit through shoot, don't shoot scenarios, where 3 different kinds of threats were presented to officers during these shoot, don't shoot scenarios. 1, definite threats. 2, non-threats. And 3, indeterminate. You're going to hear that when a threat presented itself to the Vice unit, they were reminded of their training. That training was enforced. You are to shoot until the threat is over, meaning the threat stops moving and it is no longer there. You're going to hear that Andy Mitchell was trained by Officer Gagnon on that day, participating in these shoot, don't shoot scenarios. Officer Gagnon is going to walk you through the protections and the controlled environment with respect to the shooting range. Listen as he talks about the mechanics of how the range is designed. Pay close attention, ladies and gentlemen, and contrast those mechanics logistically with the vehicle you're going to see. You're going to hear that ear protection is required at the shooting range. And that is because if a gun goes off, even at the shooting range, it could result in a loss of hearing. Imagine, ladies and gentlemen, what shooting in a confined space like a car without ear protection would do to your ears. Also present at firearms qualifications was Laura Evans, who you'll also hear from, another Vice detective. You will hear as she explains what the directives were from her sergeant that day. The group decided on that day that they were going to go to the west side of Columbus in order to work prostitution. So they all got in their separate cars and they drove to the west side of Columbus. After qualifying for the range, they did just that. Drove to an area known as the Bottoms. You're going to hear that Andy picked up who he suspected was a prostitute. He starts his audio recording issued by the city cell phone. You're going to hear that Donna Castleberry told him where to go, told him where to park his car. You're going to hear testimony that oftentimes, if prostitutes direct you where to go, and you as a police officer decide to ignore their instructions, they suspect that you're a police officer and will not hesitate to jump out of a moving vehicle. Now you're going to hear the probable cause that existed for Mr. Mitchell to place Donna Castleberry under arrest for solicitation. She tells him $25 for the sex act. And then you're going to hear that Andy announces that he's a police officer. And he is going to arrest her and place her in handcuffs for his safety. Now you're going to hear the escalation by Miss Castleberry. You're going to hear her increasingly become non-compliant. She refuses to answer his questions. Now again, ladies and gentlemen, you're going to hear that there was a reason for her non-compliance. Because one, she had heroin on her person, and she was looking to score more dope after finishing her business. And two, because she had a warrant out for her arrest. She did not want to go to jail. The evidence will show that she starts scrambling, trying to think of anything to get her out of going to jail. So she comes up with, she's going to say that she doesn't believe that Andy Mitchell was a cop. You're going to hear about all of the evidence that Andy Mitchell showed her. Indicia that in fact he is a police officer. Now Andy did not have his badge on him, but that's not required. That was not required back in 2018 as part of the Vice standing operating procedures. Undercover officers typically don't have their badges on them in case they get held up in a life or death situation. You're going to hear what he did have on him was his Columbus police identification card with Andy Mitchell's picture on it. You're going to hear that Andy Mitchell showed her handcuffs, the keys to the handcuffs. Miss Pritchard described it as a piece of paper. Ladies and gentlemen, this was a piece of paper, an arrest information report, what's known as a U-10-100 that is not accessible to the public, that was not accessible at a courthouse. He shows her that. He says, I'm going to call my buddy for backup. He tells her all of these things to corroborate the fact that Andy Mitchell was in fact a police officer back in August of 2018. Then he tells her he was going to do a warrant check. And as long as she had no warrants, he would not take her to jail and issue her in pursuant to a summons. But the evidence will show that upon realization that Andy was going to do a warrant check, she escalated the situation from non-compliant to violent in a matter of seconds. Miss Castleberry pulls out a knife. You're going to see the knife. She feloniously assaults Andy Mitchell with a deadly weapon while he is buckled into the driver's seat of his Mitsubishi. She slashes him deep enough to require 34 stitches, surgery, and an emergency transfusion. The evidence will show, ladies and gentlemen, that Miss Castleberry continues to escalate and fight Andy. She maneuvers herself to put her back up against the windshield, puts the bottom of her foot up against Andy Mitchell's throat, while Andy was still buckled in, has control of her hands to try to make sure he doesn't get slashed again. But the more he pulls, the harder her foot begins to collapse on his windpipe. The evidence will show he begins to lose consciousness. The evidence will show he realizes that if he does not let her go, then she's going to choke him. So he has no choice at that moment in time but to release her. And at that moment, she climbs into the back seat. Andy still perceives her as a threat as she is maneuvering into the back seat behind him with a slashed hand that is bleeding profusely. He doesn't know where the knife is, thinks she could still have a knife, thinks she could potentially have another knife, when he decides to use deadly force to stop the threat in this life or death struggle that did not end. The audio you're going to hear again and again. You heard Donna say, okay, and I'm sorry, multiple times. But the evidence will show, ladies and gentlemen, is just because that phone heard Donna say that, in no way, shape, or form indicates that that's what Andy Mitchell heard on August 23rd, 2018. You're going to see the car, ladies and gentlemen. Look at how small it is. Imagine that life or death struggle that I just described for you while looking inside that vehicle. Now, most importantly, ladies and gentlemen, and Mr. Collins talked about this in voir dire, but the physical evidence will in fact corroborate that chain of events. Listen as we present corroboration for that chain of events. Now, I told you 2 avenues were going to be pursued in order to assist you in determining what a reasonable police officer would do on the scene of August 23rd, 2018. Talked about the first avenue, the factors, but the second avenue is an expert by the name of Kevin Davis, a recipient of the Ohio Attorney General's Distinguished Training Award, who has been on the beat as a law enforcement officer for the last 37 years. He's going to walk you through the factors that the judge is going to instruct you on and assist you with the application of those factors to the facts as they were occurring on August 23rd, 2018. Again, factor 1, the severity of the crime. Listen as he walks you through what goes through a reasonable police officer's mind when that reasonable police officer is attacked with a knife. He's going to tell you that she continued to be a threat after slashing him with a knife because she then maneuvers to choking him. Factor 2, that she posed an immediate threat to Andy. He is going to walk you through the immediacy of a threat by a person who attacks a police officer with a knife and then proceeds to choke that police officer. He's going to talk to you about research concerning that immediacy. Listen, as his opinion will in fact differ than that of the state's experts. But Mr. Davis's explanation, ladies and gentlemen, will simply make common sense. Factor 3, the suspect actively was resisting or attempting to evade arrest by flight. Mr. Davis is going to walk you through what a reasonable police officer does when a suspect is actively resisting or attempting to evade arrest. He will confirm the reasonableness of Andy's decisions. Factor 4, her demeanor. He's going to talk about her demeanor and how a reasonable police officer would act given how she was acting. Factor 5, the duration of the confrontation. Mr. Davis will walk you through what a life and death struggle looks like for the duration of the 47 seconds. He will tell you that all of the shots occurred within 15 seconds and exactly why it is reasonable. Factor 6, the possibility of the suspect being armed. The biggest difference, ladies and gentlemen, between what the state's expert will tell you and what our expert will tell you is that Jamie Borden is going to speak a lot about potentials. But ladies and gentlemen, common sense will dictate, just as what Mr. Davis is going to tell you, that this was no potential threat. This was an actual threat, and that training mandates and that case law mandates that when an officer is under immediate threat of death or serious physical harm, that officer is to shoot until the threat stops. Now, the judge is also going to give you an instruction that a mistaken officer can still be reasonable. So you're going to hear that even if Andy Mitchell was mistaken about Donna Castleberry still being a threat, even after being attacked with a knife and after being choked, he is allowed to be mistaken and still be reasonable. You're going to hear that the law affords him that protection. Again, ladies and gentlemen, we do not believe the state of Ohio will have met its burden of proof beyond a reasonable doubt, because their witnesses will contradict one another and their witnesses will contradict the physical evidence. However, if you do find that the state of Ohio has met its burden of proof beyond a reasonable doubt, we believe the evidence will have shown you that we met our burden of proof by a preponderance of the evidence, as we will have shown you that it is more likely than not that Andy Mitchell believed he was under imminent threat of great bodily harm or death because he was attacked with a knife and choked to the point of almost losing consciousness. And 2, that more likely than not, Andy Mitchell's actions were reasonable based off of the totality of the circumstances from the eyes of a reasonable police officer on the scene, standing in Andy Mitchell's shoes with Andy's knowledge, his training, and his perception. As such, at the end of the case, my partner, Mr. Collins, will come before you and ask that you find Andy Mitchell not guilty of both charges, as he is entitled to the defense of justification. Thank you.
All right, ladies and gentlemen, we're going to do I have to find this, thing. We're gonna take a lunch break. What time do you need them back here in order to get them down on the bus? It's probably gonna take them a little bit. 1:15. We're gonna take a break till about 1:15. And then, do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. And they'll take you out to, various locations here in Columbus. And then, you'll be brought back to the courthouse. You'll be released for the evening. And then again, if you can come back by 8:45 tomorrow so we can get started at about 9, and go from there. All right?
All right.
You want them up here at 1:15, right?